Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. Today we're going to take an in-depth look at the area of medical malpractice. We'll discuss what constitutes medical malpractice, the difficulties involved in trying such a case, and the legal and moral issues involved in protecting doctors who are repeatedly involved in medical malpractice litigation. Our guests are Thomas Moore. Tom is a partner in the law firm of Kramer, Dilloff, Tessel, Duffy, and Moore. Tom represents the victims of medical malpractice. We also have Dave Major. Dave is a partner in the law firm of Smith, Major, Director, and Wilkins. Dave represents the insurance carrier. Our third guest is Dr. Jeffrey Kaplan. Dr. Kaplan is with the South Island Orthopedic Group. Also, Dr. Kaplan sits on medical malpractice panels. Hello, Tom, Dr.
Hi,
Kaplan,
Alan.
Dave.
Alan.
Tom, why don't you start off and tell us what is medical malpractice?
Well, I guess medical malpractice, most simply stated, is a failure to adhere to a certain standard of care that's generally accepted under the circumstances that results in harm to a patient.
Now, Dr. Kaplan, I know you're here, and I know you have various views on attorneys and the malpractice system in general. Can you basically give us a little summation on what those views are?
I think that the views are not specifically of attorneys. The views are not specifically of being sued by attorneys. The views are really trying to manage patient care, trying to take care of patients, and at the same time trying to protect yourself from being sued in the case of a malpractice issue. We are not gods, we're only people, and we try our best to practice within the realm of what's appropriate.
Well, how often do you think about medical malpractice?
Medical malpractice has become a thought process on a daily basis for every doctor who practices medicine. When I was in medical school at medical conferences, we would discuss topics of medicine. As I went through my training, it became that a portion of the time would be spent trying to protect yourself from a medical malpractice issue. And it's bothersome to physicians that we've got a problem with this, because now instead of discussing medicine at times at medical conferences and meetings, monthly meetings, which we have at all of our hospitals, we're kind of beset with discussing issues that are not related directly to our understanding of patient care and our dealing with patient care. And this I find to be a very big problem we've got in the field of medicine now.
Dave, what do you find is the hardest thing about representing doctors?
Well, sometimes doctors have a given animosity towards all lawyers, with all due respect. And it's very hard to communicate with them and to try and tell them that you're on their side and that just because you're an attorney, you're not after their dollars or their pocketbook. Once we can get over that hurdle, we can get to the facts. But they're very upset about the medical privilege and in talking to us, especially if we are assigned by an insurance company, which we are, as opposed to being their best friend or their family doctor or their family lawyer.
Tom, what happens if a patient goes into a plastic surgeon, for instance? I'm getting away from Dr. Kaplan's field, he's an orthopedist, and let's take a common thing. She's having a breast reduction, and it doesn't work out. It's a bad result. Is that malpractice?
A bad result classically is not malpractice. And as a matter of fact, within the field of medicine, there is the concept of risk of the procedure. It's an often overused statement in the defense of a case where there is malpractice to state that it's a risk of the procedure. But obviously there's no guarantee, and probably guarantee in medical care, and probably the area you've quoted, namely plastic surgery, is the prime example of that. That while there are standards that a surgeon must adhere to in doing a breast reduction or a facelift or whatever, there are certain risks inherent in that procedure, and if they occur, the surgeon will not be held accountable.
Dr. Kaplan, would you agree that a patient who feels that medical negligence has been, she's been the victim or he's been the victim of medical negligence, has a right to bring an action against the doctor?
Yes.
If you had the ability, would you change the system as it is now?
Yes.
How would you change it?
Yes, I think that what is most important to keep in mind is the concept of tort reform. And I think that pain and suffering is something that is being given a ticket, a price, that's way beyond what we would like to see. I think if someone is the victim of a gross negligence and a gross malpractice out of the scheme of what is appropriate for that community, and someone has a very bad result and is injured by a physician from a gross malpractice act, I think if that patient wishes to take that to court, I think the patient deserves to take it to court.
Well, let me see what the victim's attorney says.
Okay, well, that reminds me of the story of the juror in voir dire. Voir dire is when you're selecting a jury and you're talking to them about their ability to be fair on a case. And you say to them, well, this case happens to be a case involving a suit against a hospital or doctor. Do you think in that kind of a suit, as opposed to, say, a car case or a construction case, you can be fair to the plaintiff and judge the doctor and hospital fairly? And they say yes. But on a little more questioning, it comes out that maybe if the doctor happened to take off the wrong leg, they could say that was malpractice. But when it gets to finer areas that are still clear in terms of negligence, they're incapable of finding fault. And that dovetails with what Dr. Kaplan just said. If there's gross negligence, then there should be accountability and remuneration. But that's not the standard that others are held to in life. You have to adhere to a standard, and a gross deviation is certainly compensable, but any deviation that results in harm should be compensable.
Well, I disagree with that, and I think that the problem is what the concept is of what a result should be from a particular type of problem. If a patient is 75 years old and breaks a hip and shatters the hip and the hip is put back together and you get the patient back to functioning, but this patient's got a bit of shortening and some rotational abnormality as a consequence of the fracture that was repaired, there are some people who would look at that and say, I don't want shortening of my leg. I don't want a rotational abnormality of my leg. But if that's the only way in which we can get that patient's leg to heal, the concept is, has there been a malpractice committed against that patient? The answer is no. That patient will still go to an attorney if the patient desires, and maybe find that attorney will take such a case.
Dave, what do you think?
No, you see, doctor, once you start using words of gross negligence, you may not be aware of it, but
It's a word of art.
It's a word of art, okay? And you're taking it into a different context. And perhaps gross negligence is best described as something not covered by your insurance policy. I mean, you're talking about
which gets us to a different topic.
Which gets us to a different topic. So you're talking about punitive damages when you're talking about wanton, malicious, and gross. And I think that Tom is talking about a standard of care. And yes, he's absolutely right, and as are you, that there are no guarantees. But it depends upon the type of procedure. A general practitioner is held to one standard of care, and an expert, of course, an orthopedist, is held to a different one.
Dave, you represent doctors. What happens in the instance where a doctor is sued not only by one patient, but numerous patients, and has a whole string of lawsuits? Is he still allowed to practice in the hospital?
Unfortunately, I don't sit on the legislature. I have different ideas about this. I believe that just as a lawyer is held to certain standards of care, we, as attorneys, if we do something wrong, we can go before a bar association, we can get suspended, we can get disbarred if we do something so horrendous. And I do think that there should be an agency, perhaps a state agency, so that chronic malpractice offenders could be removed from operating room theaters.
Tom, I know you're sitting on the edge of your seat and you want to respond, and we'll respond right after this break. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is, there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors, or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
Lawyers, like medical specialists, limit their practice to certain areas of the law. At our firm, Zalman & Schnorman, we specialize in personal injury litigation. We concentrate on helping injury victims receive fair compensation, and there is no charge for our legal services unless we are successful. If you are too injured to come to our office, we will come to see you. At Zalman and Schnorman, we care about you.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hello, I'm Alan Schnorman. You're watching Lawline. Tonight's topic is medical malpractice. With us is David Major, Dr. Kaplan, and Thomas Moore. Tom, you were just about to say before the break?
Well, what was I about to say? Dave just mentioned something that is not quite true. There is some limited disciplining of physicians in the state, and chronic offenders, chronic perpetrators of medical malpractice can be disciplined. But the total import of what Dave said is correct, that it is very, very difficult for such a process to eventually result in a license being taken away or an inability to practice medicine. And by and large, many incompetent physicians, again, chronic offenders in terms of people who commit medical malpractice, go on blithely on their way practicing medicine.
Tom, I know you've received over $25 million verdicts in the medical malpractice field.
Well,
Are there...
two of them were not in medical malpractice.
Okay, to be accurate. But are there certain areas where patients are more at risk? I mean, are there, whether it's at the gynecologist or where?
Okay, there are areas, I think, that a patient is more at risk in terms of vulnerability. For instance, Dr. Kaplan's field, orthopedics, is, and I, by the way, agreed with Dr. Kaplan in the example he gave of the 75-year-old who had a shortening and didn't like it. It may well be that with a serious hip condition and an effort to rectify it, that the person is left with a result that they're not pleased with. And just not being pleased with the result does not mean that you automatically can get a lawyer and go into court and recover. So, you know, I share his opinion on that. And on orthopedics, it is a generally difficult area because most of the time somebody like Dr. Kaplan is facing a pretty bad situation to begin with and is trying to rectify it and correct it. Now, I still say that orthopedic surgeons can still deviate from standard norms and cause harm to a patient. But I think areas other than orthopedics, for instance, obstetrics, pediatrics, other surgeries, thoracic surgery, are emergency room medicine where a person is admitted and treated and decisions are made quickly, and sometimes the quickness of the decision has something to do with the result, but many times bad decisions are made even with time to make correct decisions.
Dr. Kaplan, are you ever in an emergency room?
Sure.
Or how do you think about, what do you think about what Tom just said about when you have to make an emergency decision? Are you worried about, well, if I do this or do that, will it be malpractice? Will I be sued?
No. I think the training that comes in is such that you do, this is what I do for a living, and I'm accustomed to doing it. I don't think about what I'm going to do in an emergent situation based on whether or not I'm going to be sued for it. That's not the thought process that doctors do. But I will say that I think that the numbers of, for instance, you mentioned gynecologists, the numbers of C-sections, cesarean sections that are performed have increased tremendously in this era of malpractice, where gynecologists can be sued 20 years down the line for a child who might have had a nerve injury from a vaginal delivery. Nowadays, if there's a disproportion, meaning the child is kind of big for the canal, the gynecologist will go and say, I'm concerned that there's going to be a problem with this delivery, and there are more and more cesarean sections for that reason. And now at every meeting, at every medical executive meeting. The numbers of cesarean sections are discussed, and all those numbers are trying to be brought down. The indications are trying to be narrowed.
May I just say
Yes.
that I agree that cesarean sections are being done far more than they should be in terms of the general consensus, but I disagree with the reasons entirely. I think the vast majority of cesarean sections that are done that should not be done, and let's say there are ones being done that should not be done, are done for convenience. They're done for the convenience of the doctor, they're done for the convenience of the patient. It is very rare that a cesarean section is done that would not be done because the doctor has this consciousness of being sued or being accountable for something that happens.
I disagree with that, and I think that if you're talking if a gynecologist is talking to you or talking to me and saying, well, I'm going to do an operation instead of delivering your baby vaginally because it's kind of late. I'm sorry. I don't see it that way. I don't see how any family can accept it.
Dave, you want to say?
Yeah, I think we're missing the point. The point is, did the doctor commit a standard, did he do something outside of the norm? For example, it's not whether or not the doctor did a C-section, it's whether or not the doctor had a few drinks before coming into the operating room.
Dave, let's take that doctor who had a few drinks before he came into the operating room, and he knows he botched the job.
Absolutely.
Does he have a requirement? Does he have an ethical question of whether or not he tells the patient or not? What happens in that instance?
What happens in that instance is he usually clams up very quickly because he's afraid of the malpractice.
Well,
He knows it very quickly.
what about the nurse who was in the room? What about the other people who was in the room, the technicians? Do they have any obligation to tell the hospital board?
Well, I don't know about the Hippocratic Oath, is that what you're talking about? But legally are you talking, or ethically or
Well,
morally?
what should they do? What do the hospitals say they should do?
I don't know what the doctor should do vis-a-vis the hospital, but if a doctor does something absolutely incompetent, as we're talking in that discussion, the law provides a way for people to get redress from that, and that is to bring litigation.
Yeah, but what if they don't know they've been malpracticed on?
Today, in this day and age, people are litigious, and they know.
Tom, how do you feel
I
about
disagree
that?
entirely. I think every objective study that's been done on this issue of medical negligence has come up with the principle and notion that the amount of malpractice that sees the light of day of litigation, if I may use that phrase, is infinitesimal compared to the amount of malpractice actually being committed.
Well, let's go back into that
And if I might
operating room.
if I just might say, in reference to what Dave was just talking about, I think it's clear there's an ethical obligation to speak by a nurse or a technician who sees a physician functioning improperly. But in practice, I must say, by and large, that ethical obligation is not adhered to, and nobody ever knows.
Well, let's look at it from the other side. Dr. Kaplan, you're in that emergency room, you're in that operating room, and you see malpractice. What happens? What do you do? What does the other people do?
Well, I would say for sure that if I personally saw someone who was under the influence of alcohol or drugs and was practicing medicine going in to do a surgical procedure, it wouldn't happen in front of me. I wouldn't permit it to happen.
Okay, but of course that's the gross case. What about when you just see, you just saw a colleague commit malpractice on a patient to the patient's detriment? What is done? Is there any ethical considerations?
The truth of the matter is I can't specifically tell you. I have never been exposed to something like that happening. An adverse result is a different issue. I have
We're not
never
talking about
watched
that.
somebody commit malpractice. I've never seen it happen. I really haven't.
Well, I know you're on the boards of many hospitals.
I mean, when a sponge is found on a post-operative X-ray, we didn't watch that sponge stay there and not say anything about it. So I'm saying I haven't watched somebody commit malpractice. And if I did, I wouldn't tell the patient about it.
Why not?
I would. It's inappropriate to tell the patient that your doctor just committed malpractice against you.
Well, who tells the patient?
Well, if I may, if malpractice is committed, the patient is injured. If the patient is injured, the patient will know about it. If the patient knows about it, she'll go to another doctor. The other doctor will tell the patient that something is wrong because of malpractice, and therefore Tom theoretically gets the case.
Oh, I
I'm gonna
disagree entirely.
I'm going to ask Tom about that right after this break. We're watching Law Line. Stay with us. Interesting show.
My father taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack, except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how.
If you are injured in an automobile or any type of accident, you may have the right to fair compensation for injuries, pain, and suffering, including loss of wages. So if an accident leaves you disabled or unable to return to your job, put our law firm, Zalman & Schnorman, to work for you. There is no charge for our legal services unless your case is settled or won. Call Zalman & Schnorman, who is specialist in personal injury litigation.
Talking computers, high-speed braille printers, new technology helping blind and visually impaired people participate fully in today's computer age.
And removing the top of page.
For more information about putting high technology to work for blind people, write American Foundation for the Blind, National Technology Center, Box 111, New York, New York 10011. The American Foundation for the Blind.
Hello, I'm Alan Schnorman. You're watching Lawline. Today's topic is medical negligence. With us is Dave Major, Dr. Kaplan, and Thomas Moore. Tom, you were just about to say before the break in response?
I'd like to think that what Dave just said is true, but unfortunately experience tells me otherwise. As a matter of fact, many, many times the patient is the last to know. And it certainly dovetails with what I said earlier, that there is far more malpractice going on than patients know about.
Now, Dr. Kaplan, let's assume that a doctor has been sued for malpractice a number of times in one of the hospitals that you're connected with.
Yes.
Does it go before a board of review? A peer board or something?
Each year, a doctor's hospital privileges is reviewed. The privileges are reviewed. And whether or not a physician is reappointed to the hospital depends on the physician's record. And that physician's record reflects the malpractice cases that the physician has had against him or her. I must tell you that in my years of experience right now in being a physician and in the years of training in hospitals and medical school, I've traveled through many different hospitals, and I will tell you that physicians who practice with the most difficult cases, in the most difficult areas, with the most difficult patient populations to follow, are sued often, especially in teaching programs. And they take tremendous risks and treat patients with very high risk for bad results from injuries.
Dr. Kaplan, have you ever declined treating a patient because you thought it was a difficult situation and you may not be able to do it properly?
Yes.
And I think that's the right reaction. I think a doctor should take a patient on the ability of the doctor. You would not go to a plastic surgeon to fit a fractured femur. You go to the correct doctor, and if the doctor feels he's not equipped to do that, I think he's duty-bound to tell the patient that. I think doctor is absolutely correct.
Tom, just to change the topic just a bit, you can't open a newspaper or turn on a TV station without hearing about AIDS. We're certainly in an AIDS crisis here in the metropolitan New York area, if not the entire country. What's the situation on malpractice and AIDS? If somebody receives a transfusion at a hospital, and it's later learned that they received AIDS because the transfusion was infected, can they sue?
Possibly. Certainly there's been a change in our knowledge of AIDS, and there came a time when this became a common problem, and it was known that there was a possibility that blood was contaminated. Prior to that time, say in the late 70s and early 80s, it would be very hard to establish negligence against a hospital or healthcare provider in terms of a transfusion because simply AIDS wasn't even understood or known. In the late 70s, it wasn't even known.
The person may have a case, may not.
Certainly, more recently, if a person goes into a hospital and gets a transfusion and that transfusion is contaminated with the AIDS virus, they may well have a case.
Dave, there's a case...
Wait, there's a major problem in what you're talking about with AIDS, and that's called the plaintiff's attorney's AIDS psychosis. And every case that we see now, can't say every case, but most of the cases from plaintiffs' attorneys where there's any bloodletting, any shots or anything else like that, they throw in the fact that the patient, or now the plaintiff, is afraid of
Well,
contracting
Dave,
AIDS.
I know there's a major case now pending right here in the city of a doctor who has contracted AIDS. And it's her claim that she contracted due to the negligence of the institution, the hospital. How do you feel about that?
I think that she, as anyone else, if the institution failed to provide proper care, proper gloves, etc., the institution should be responsible vis-a-vis workers' compensations laws and different things like that if they're applicable.
Dr. Kaplan, I know you operate every day. I know you must be in blood every operation. How do you feel about this? What's your concerns?
We're very concerned, and I think that the next 10 or 15 years will certainly turn up more and more cases of work-related operating room, renal dialysis, heart pumps, bypass pumps, people in the medical field, physicians and ancillary personnel who will come up AIDS positive.
If they don't claim that they were affected by the asbestos in the air.
Yeah.
Right.
And I think that this is a major health issue. I don't look at it as a malpractice issue. I look at it as a specific reality in my lifestyle, a lifestyle of people who care for patients, especially patients who are in that high-risk group.
Let me just ask an aside in the moment we have left. Have you changed your procedures any? Are you concerned with AIDS personally?
Yes, we have. As a matter of fact, one of the problems you should be aware of is that, a quick aside, is that a friend of mine had applied for life insurance. And in that life insurance application, one of the things they did was draw blood. And they said, oh, by the way, we're drawing blood, and one of the things we're going to do is draw bloods to see if you're AIDS positive. This friend of mine told me this, just as an aside. Well, she was AIDS negative. In order for me to draw blood from a patient, in order for an AIDS blood test, I have to sit down and counsel a patient about what the possibility is if they have a positive test. An 8-page document has to be signed.
We're going to have, obviously, a separate show on this very issue. Dave Major, thank you very much. Dr. Kaplan, Tom Moore,
thank you.
Thank you all for appearing on Law Line. And as always, thank you, our audience, for watching Law Line.
You have been watching Law Line with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Law Line, 27th floor, 63 Wall Street, New York, New York, 10005.
Involved in a case some 10 years ago where he said in a tape-recorded situation how much he hated Jews and how much he hated, especially as a German, as someone of German extraction, Jew lawyers.
Well, do you think his attitude toward Steinberg was totally prejudicial because of that?
Well, we felt that he hated Joel. I mean, his manner on the witness stand and his referring to Joel throughout his testimony as Steinberg, you know.
Jerry, if that would have come out on trial, would it have had any effect on the jury deliberations?
I doubt it. We proceeded on the basis of a set of proven facts in the case that, in our minds, made it inescapable that Joel Steinberg is the one who delivered the blow that led to Lisa's death.
Jerry, take our audience into the jury deliberation room. Why did it take 7 days?
8 days.
8 days, excuse me.
Two aspects of it. The first half, roughly, of the 8 days was convincing a minority of the jurors that Joel Steinberg must have struck the blow. We went through a chain of reasoning.
Joel Steinberg as opposed to?
As opposed to the only other adult in the household had a nussbun. Those were the only two possibilities. We made it very clear. Look, here are the only two people there. One of them had to have struck the blow, and let's look at what the possibilities are.
And there was no question in your mind that a blow had been struck?
None. Both defense...
that was conceded out.
Okay.
Right.
We conceded through our own expert. I mean, there was just no point not to. It was very clear that she had received 2 massive blows, at least, to her head. There was one misconception about the case, and I'm sure